Good day, Internet. This is Chavez and Valko, the key to your immigration solutions. I am Senior Associate Ben Hamilton, and with me is Associate Attorney Andrew Craven. Andrew, how are you doing on this icy morning in Texas?
Doing good, Ben. How are you?
I am doing well. We are continuing with our series on all the different employment based residency categories. Right now, we're doing our series on the Perm labor certification process. So we did a video on the prevailing wage, did a video on recruitment, and today we're going to be focusing on the actual Perm itself, which is the ETA Form 9089, right? But a little bit of a recap. Andrew, in discussing the Perm labor certification process, what is our first step?
So, our first step is filing the ETA Form 9141, which is the prevailing wage determination. So, once all the job duties and everything are put together, submit it to the DOL, get an actual wage level to pay the employee.
Yeah, I mean, the main things going into that are the job title, description, requirements, and job location. Of course, what we're getting back is the Department of Labor selects the job code and the prevailing wage. Again, we have a whole video on that you can go look where we discuss in detail the 9141. How long do those take to get back from the Department of Labor?
Approximately 160 days.
They don't publish processing times. These are just based on us keeping track of the how long our cases are taking. Roughly 160 days. What is the validity of the prevailing wage determination?
So, that prevailing wage determination is valid for 6 months.
All right. And then what is our next step once we have that prevailing wage determination?
After that, then we're going to proceed with recruitment. So actually testing the market for US workers.
And what are our mandatory recruitment steps that apply to essentially all perm cases?
So it's a state workforce agency ad, two Sunday ads in the newspaper, and a notice of filing posted at the worksite.
And who is required to engage in additional recruitment on top of that?
So, for what would be considered professional positions, the employer must engage in three additional forms of recruitment out of 10 total options.
And when do I have to start my recruitment?
Either before or dealing during the prevailing wage validity period.
It is possible to do it before, but it is risky because you don't want to do your recruitment thinking you're going to get A, but then the Department of Labor comes back and actually gives you B. So it can be risky to start it before. And then when do I have to end my recruitment?
So it has to be no more than 180 days after you start, including the mandatory when you start, and then that includes the 30-day quiet period.
So the simple way to look at it is my prevailing wage gives me a 6 months period in which I need to start my recruitment. I don't need to end it within that 6 months. I just have to start it, and then that starts another 6 month clock in which I have to conclude my recruitment, including the quiet period. So I've done my got my prevailing wage back. I ran my recruitment. It's now all done, including the quiet period. I have reviewed all of the resumes I received. I was able to disqualify 100% of the candidates, meaning none of them were qualified, willing, or able to take the job opportunity. And now I want to move to the next step, which is filing the actual perm labor certification for that specific employee. So first off, a little bit of the administrative how this actually works out, right? So when I file the prevailing wage determination, where do I actually file that?
So you're actually filing that with the Department of Labor's Foreign Labor Application Gateway or FLAG website.
So this is a cool website that came into being around 2019. Cool being that it's like relatively modern compared to most of the government websites we have to deal with, which are just trash. Um, but it's where you do your 9141s related to perm, also related to H2Bs and H2As. You can do your LCAs there. When you submit a prevailing wage determination, so the attorney, we go and create an account. Does the employer have to be involved in the actual submission of a prevailing wage?
No, so there's actually zero input from the employer at this stage. It is all the attorney setting up the account, creating the form, and then submitting it.
Now, obviously, we want the employer. We get the information from the employer. We want them to review it. But technically, as an attorney, you can create an account and go in and submit a prevailing wage for anybody, basically. But how do we prepare and submit the ETA Form 9089?
So for that, you're actually going to go through the DOL's website called the Foreign Labor Certification Permanent Online System. So it's a different website, definitely not as modern as the flag system.
No, this one's been around a lot longer, and hey, look, I'm going to be honest here. The Department of Labor is way ahead of the curve when it comes to the other agencies we deal with. In terms of they are better. I would say the worst is the Department of State and the DS-160s and DS-260s, which is a terrible website. So give the Department of Labor credit. Still not very modern, but they are ahead of their brothers in the USCIH and the Department of State, USCIS and the Department of State. So does the employer need to be involved in the submission of a perm?
Yes, so the employer actually has to create their own account and add the attorney or authorized representative.
So here we were displaying a document that we send to some employers in terms of just kind of walking them through, right? Like, okay, here's the website, you have to register, and then it shows on there's more pages where it shows, hey, this is kind of what it looks like in terms of creating your user profile, creating your company information, right? And then when you get down to once you've created your account, then you can add a user and then we can go in. Now, here's the weird thing is that each company we work with has to add us as a user. So, Andrew, if let's say there's 60 companies we're currently working with and preparing perms for, how many logins and passwords do we have to this website?
60.
Yeah, so
One
you got
for
to keep us.
each company.
It is, yeah, that's one of these reasons why it's like you can't link it to an attorney account, and then we just have one account. But then as employers get linked, they just kind of no, we have a separate. It's really weird and frustrating. But let's jump into the actual ETA Form 9089 itself, right? This is actually quite a long form. Once it's fully submitted with all the details in it, it can easily be 15 to 20 pages long, um, full of information with a lot of things that can trip you up. So here it is, page 1. As we said, Part C is the employer information, Part D is the employer contact information. On the prevailing wage, we're putting that information in. But here, the employer is putting it in and we can't change it. So this is one of those times where you have to like really emphasize with the employer. You have to go in and do this and make sure you do it right. Like for example, if they go in and they're like, "Oh, we're just going to put in our trade name." I don't know. They're just going to put employer's name. They're just going to put in like Facebook, right? And you're like, "Well, is it Facebook? Is it Meta? Like, Google versus like, ABC or whatever the heck it is." It has to be accurate. And of course, you want to match the prevailing wage determination. So when it comes to the employer's name, they need to put the true legal name, the headquarters address, the FEIN, NAICS code. All of this stuff has to be accurate. I mean, we had a recent employer who we submitted it, and then we realized like the contact information was, well, the employer tells us, well, the contact information is wrong. That guy no longer works here. HR no longer works here. And we're like, you didn't tell us that, and we can't change it. So it is important that the employee or be very accurate in terms of this C and D because we can't change those. A really important question there is number 9, Andrew. What's that about?
Let me see here. Sorry, I'm on the little screen today. Yeah, so I mean, there we're really getting into whether or not the alien has any ownership in the company, and that's going to affect whether or not they're actually allowed to file the 9089, among other things.
let's just say our preference is to always, always, always check no to number 9, meaning, do you have any ownership in the does the beneficiary have any ownership in the company, or are they related to an owner of the company? Because the second you check yes, we're going to talk about this later down, but you will get audited, right? And they're going to look at whether or not there was truly good faith recruitment conducted, right? Because if for example, if the employee is like a 50% owner or even more, it's like, well, how could you possibly have good faith effort recruitment? Because they're going to have control over that. So obviously, if the employee does have ownership, but it's like, oh, I just got some stock options and it's like 1%, right? Then that's usually not a problem. Like, you can get around that. Or, sometimes they are related to the owner, but maybe there is an actual independent HR, and the owner's like, I'm hands off. I'm not related. The HR handled all of the recruitment, all of the everything, and you're able to document that. So obviously, just because you check yes to number 9 doesn't mean you're going to get denied, but it is 100% means you're going to be audited, and it also means that you need to have been prepared for that from the beginning, right? To make sure your recruitment was done in such a way so it passed muster. You can't do your recruitment and then realize once you're filing your perm, oh yeah, the owner's my uncle, and you're like, oh, okay, and so that was your uncle. That was the guy who was doing the recruitment too, and you right. And then you're like, this is not going to go well, right? So that is one of those questions you need to address at the beginning so that you can take the steps you need to make sure that you can get through this. So moving on to the second page here, um, most of this is coming directly from the perm, right? So they're saying, or sorry, from the prevailing wage determination. So prevailing wage tracking numbers. So all prevailing wages get assigned a number. It starts with like a P and then it's a bunch of digits, right? So you put in your prevailing wage number there, the SOC code from the prevailing wage, the title you use. I mean, this is all coming from the prevailing wage, right? So F, G, H, all of this information should be matching exactly what is on the prevailing wage determination. You're seeing there's like a wage offer. Usually, like, the prevailing wage is the minimum, and then you can put a higher range. Like, say I have multiple employees, the prevailing wage is 80, but I have employees in that position that are making anywhere from 80 to 120, right? So then I could put 80 on the lower end as the prevailing wage, and then 120. So there's a range there. Actually, Andrew, I'm gonna trip you up. Skip back a second to the first page where we put in the employer information. What happens if there's a merger or acquisition or something there changes during the process in terms of who the actual employer is?
I mean, in that situation, we really want to look at how that change happened. What is the structure of the new company, and figure out if they're going to ultimately be what's called a successor in interest. Basically, did they acquire the original company in such a way that they have taken the rights to this whole process? Or, is it something a little murkier where you might have to start over from scratch?
Yeah, so it's a great thing is like we bought this company wholesale. Like, we whole everything, right? We took the employees, everything, or we merged, right? And took everything. What we don't like is like, oh well, company B bought the assets of company A, but like essentially fired all the employees, rehired a couple. That's one of those where it's like, uh-oh, that's probably not going to work, and we would have to restart, right? We're not going to get into the nitty-gritty of it, but the main question is, does it qualify as a successor in interest? And then maybe you would be able to continue with the process and not have to restart. So again, we have to kind of look at that. So going back, right? I mean, page 2 is largely information coming directly from the perm. You can't just suddenly change, I don't know, the work site location, because remember the prevailing wage is based on the work site location. So you can't all of a sudden get to the 9089 and be like, oh, well, no, he's going to New York now, but this was done for Houston, Texas. And you're like, well, no, that's changes everything. Um, Also, in terms of the requirements, right? Again, this is all from the perm. So if we go to the third page, um, it's more of the same, right? Where we put in the primary requirements, we put in the secondary requirements if there are secondary requirements. Um, some of the ones we look at is, number 6 is experience in the job offer required. Yes, how many months? And then they ask you to put in, the title, and like down to number 10 is experience in an alternate occupation acceptable. Yes, the number of months. And then number 11, of course, is the job duties. I mean, there's a lot of boxes that we have to check and fill out here, but at the end of the day, it's not terribly complicated because you're just going off of the prevailing wage determination. So sometimes where you're seeing the primary and the alternate is like, oh, the primary is a bachelor's plus 5 years of experience. The alternate is a master's plus 3 years of experience, right? Because those are considered equivalents. And so you'd have to reflect all of that information here. Where you can get tripped up is if you just make a mistake, put the wrong amount of months, or there were alternative requirements to the prevailing wage, but you didn't put them on the perm. I mean, it's just accuracy, right? But I don't think there's anything super complicated here. I love these ones, number 12 and number 13. So number 12, are the job opportunity requirements normal for the occupation? Here's one way to trigger an audit. You typically want to put yes there, but if you put no, right, you're just a lot of times the Department of Labor looks at it and determines they were not normal, and then you may get audited. But here you're just outright admitting, no, they're not normal. So you're pretty much guaranteeing yourself an audit. Andrew, how about number 13?
Is knowledge of a foreign language required to perform the job duties? So this is another one that can largely trigger an audit. I think we've had a couple of cases recently where it was sufficiently explained that they didn't feel the need to audit it, but normally that would.
And again, I look back at this and I say, feel free to use some of these fields to input that information. Because again, you're saying I'm putting in my job duties, but I'm going to check yes to the language requirement. Feel free in the job duties to add in maybe like a little detail about the company itself, right? Like, again, you should have done this back at the prevailing wage stage so it kind of all matches. But because you're looking at stuff like, well, I require this certification. Where do I put it? Well, look at box 14, special skills or other requirements. Anything you feel like needed to be put in, but you don't see a field for it, stick it down there, right? So it's on the perm, right? Just put it somewhere. The DOL has kind of admitted, hey, this form isn't perfect. Or the appeals board, which is called Valko, has admitted, hey, this form is not perfect. There's not a spot to put everything you'd want to put. So just find a place to stick it. So like, again, 14 is a good catch-all for your certifications required. It's any special skills, programming languages, everything goes in there, right? We use 11 under job duties sometimes to put in like a little bit about the company, right? Like, oh, this person has to speak Arabic. So under the job duties, we're going to be very explicit that, oh, they have, several dozen locations in the Middle East that this person is going to be directly supervising. And we kind of add that little bit of detail into the job duties, hoping that when we check yes on number 13, we don't get audited because they look at number 11 and they see the connection, right? Because if you just say yes, has to speak Arabic, and they're like, well, this person's just an operations manager, you're going to get audited, right? Because they're going to come back and be like, well, what's the business necessity for this person having to speak Arabic if they're in the United States? So again, I don't know, people may disagree with me, but I look at the number 11 and I look at number 14 as these are the spaces where you can stick stuff in, right? I mean, you can't like make up new job duties, right? But you can add in some of that detail about the business or whatever, right? So again, 11 and 14 are kind of key fields to use to get as much information in there as you can. But again, like 14, I can't put extra stuff in there that wasn't in the prevailing wage determination. And just so you know, when you're filling this out online, if whatever your text is really long, it automatically kicks it to an addendum, right? So if your job duties are super long and are not going to fit here, it like automatically kicks them to an addendum. So you don't really have to worry about that. All right, next page here. These are more of these like weird series of questions that can just like they're actually relatively straightforward, but if you accidentally screw up, it can get your perm flat out denied or trigger an audit. Like, does this application involve a job opportunity that includes a combination of occupations? We talked about this about the prevailing wage. They hate hybrid positions. You really want to just kind of pick one and lean into it. Um, Otherwise, it will trigger an audit, right? Is the position identified in the application being offered to the alien described in Section J? Seems like an obvious question. Hey, this perm that we're doing this for, the guy who we're going to name below, is this the job you're offering to him? I mean, it seems like a stupid question because it kind of is. But if you're not paying attention and you check the wrong box, perm denied. Done. Perm denied. Does the job require the alien to live on the employer's premises? Again, for us, 99.9% of the time, that's a no. I mean, there are jobs that do, but it's usually a no. Is the application for a live-in household domestic servant worker? Again, very narrow use case. It's typically no. And then we get into I. Section I's are all where we start putting in all of our recruitment stuff. So, Andrew, what's our first question there within Section I?
So basically, is this for a professional occupation other than college or university teacher? Because those have their own special recruitment procedures you can take. And also just kind of outlining that professional just means that they require a bachelor's degree for the position.
Yep. So if we go back to the earlier part where we were listing out the job requirements, and if we check a bachelor's or higher, right, as the requirements, then of course we have to put yes. And then Andrew, what does putting yes in that box mean?
Putting yes ultimately means that it is a professional position and requires those additional 3 recruitment steps.
Exactly. So if you put no there, you're just going to fill out the info about the SWA, the Sunday in the Sunday ads. If you put yes there, then you better also be filling out the information about the additional recruitment steps. Again, it's really easy to just check a box wrong, bam, denied. You can't emphasize enough when it comes to perm. If you make a mistake, there is no opportunity to fix it, right? And it could be 6 months later that you find out that, oops, I checked a box wrong and bam, denied. And again, some of these, like up there on number 15, does it involve a combination of occupations? That'll trigger an audit, right? Whereas, the one we were just talking about, is a professional occupation, you get that one wrong, you're just getting denied. So again, there you check yes or no. If you check yes, obviously, two, if it's for a college or university teacher, all right, you just answer that. For us, it's usually no. And then we just skip down to section C, right? So for us, A is usually yes, and then no, and then we skip down to C. So the dates for the SWA order, pretty simple, right? We talked about, well, Andrew, how long do we want to post the SWA for?
At least 10 consecutive business days.
That's notice of
But
filing.
oh, sorry, the SWA for 30 days, 33 in the state of Texas. And with both the notice of filing and the SWA, always better to do an extra couple of days.
Yes. So obviously, when you look at that start date and that end date, it better be at least 30 days. And also, depending on your state, it could be more than 30. Like again, Texas, 33. Because the first 3 days is only open to veterans. And so it has to be 30 days open to everybody. So that's why 33. So is there a Sunday edition of the newspaper in the area of intended employment? You check yes. You write the name of the paper here. That's the Dallas Morning News, but it could be LA Times, New York Times, Houston Chronicle, depending on where you're at. Right. So you check yes, you put the name, and then you list the date, right? Of course, that date better be a Sunday. And then usually they're, just consecutive Sundays. So it could be like, oh, it was November, 23rd and then November 30th, right? They're consecutive Sundays. Again, you could screw up there, put the wrong date, and the date's like a Monday or something. There are certain little errors like that you can sometimes overcome. Like you'll probably get denied, but you might be able to overcome it if you are able to produce the actual ad and say, no, it actually was on a Sunday. I just screwed up and was off by a digit, right? But you might actually get denied, and then you'd have to file a motion to reconsider, produce the evidence, and you might be able to get that overturned. But again, it is so important to be very precise with all of your dates. So go to the next page. where if you look up there, section D, this is where we get to enter in all of our additional recruitment, right? So obviously, Andrew, we already discussed, we have to do 3 of at least 3. And it's pretty straightforward, right? You just, you put in the date it was up and the date it went down. Some of these are like a 1-day thing, like the radio or TV ads, right? That's just like 1 day, right? So it'd just be like April 1st to April 1st, right? Whereas, the employer website could be for a number of weeks. The job search website could be for a number of weeks. But it's pretty straightforward, right? Just the 3 that you did, you go fill in the info, just make sure you're precise on your dates. Here's another just trip up question that could get you audited and denied. In E, general information. Has the employer received payment of any kind for the submission of this application? Andrew, can the employee pay for anything to do with the Perm labor certification process?
Absolutely not. Anything the sort does result in any number of penalties.
Absolutely positive. Because remember, you're supposed to be doing this good faith recruitment. And so if the employee is somehow paying for it, they're instantly skeptical. Now, there are certain things they can pay for once you get past the labor certification, I-140, I-485. There, you can essentially charge 100% to the employee or 100% to the employer. It's kind of up to you. But when it comes to the Perm labor certification, Department of Labor, you can not have the employee pay for anything. So that's not the legal fees, not the recruitment costs, nothing. So when you get down to this next one, 24, 25, 26, this is where the notice of filing comes in, right? So it says, has the bargaining representative for workers in the occupation been provided with a notice of filing? Obviously, this is if you're dealing with like a unionized case. We rarely deal with unionized cases, so we usually check no, and then we go down to 25 and check yes, because if there is no bargaining representative, has a notice of filing been posted for 10 business days in a conspicuous location, blah, 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 right? That's where you say, yes, we actually did the notice of filing like we were supposed to, because if we don't, you're going to deny us. Number 26, another audit trigger. Have you had any recent layoffs? Obviously, if you check yes, we always check no, but if you have to check yes because it's true, be prepared to be audited. Because again, look at 26A. If yes, were the laid off U.S. workers notified and considered for the job opportunity, right? Meaning, just because you check yes doesn't mean you're going to get denied. You're probably going to get audited, and you're going to have to prove that you did have a layoff and then you did contact the laid off employees as part of your recruitment process. If you can't prove you contacted your U.S. employees as part of the recruitment process, the laid off employees, you're going to get denied. So far, pretty straightforward. Employer information, attorney information, the job opportunity information, which comes from the prevailing wage, the recruitment information, right? We're just filling all that out, just making sure we're paying attention and we're checking the right boxes. Because again, you screw up and check a box wrong, you can get audited or denied. Now, Jay here, this is the first time in this process that the actual beneficiary, the foreign national, is coming into the picture, right? There's nothing about them in the Perm and the prevailing wage, nothing about them in the recruitment. This is where they're coming in. Pretty straightforward, right? Hey, this is our name, our address, date of birth. Does that employee have to be in the US if we're doing this process?
No, they can be anywhere in the world when this process is started.
Do they have to be currently working for the sponsor?
No. So I mean, generally, like we've talked about before, you'll see people working on an H-1B when this process starts, but there's absolutely no requirement to be in the country, be working for the employer. You just have to intend to work for the employer once the green card is approved.
That's the key, right? Everything in here is for a future when I get the green card. So it is possible to do all of this for someone who's not in the country or who's not even working for you. And we've had cases where we've done that. That's perfectly a-okay, because again, this is all for what's going to go into effect once you receive the green card. That's why a lot of times the perm is actually for they are currently working for the employer on H-1B, but the perm is actually being done for a position maybe above the one they're currently in because it's technically for a future position. And if you're Indian, you're not going to get that green card for 10 to 15 years. So why would I do it for the position I'm in now? I really would hope that I'm not in the same position 10 to 15 years from now. Anyway, moving on to the next page. Obviously, this is where we put in the employee's education. Of course, this is key because before we put in the requirements and we said, I had to have, let's say, a bachelor's degree in computer science. Well, this is where we need to be very clear that the employee that we want to sponsor meets that qualification. Because we have to specify the major fields of study, which again should line up with our requirements earlier. We put the year it was completed. We have to put the address of the institution, and then some more fun questions that are just built to trip people up, right? Did the alien complete all training required for the requested job opportunity as indicated in H5? Well, if you said no training was required, then you just put NA, right? In most of our positions, no training is required. Experience is required, but not training. Because for us, most of what would be, quote, training usually falls under education or experience. Most of our cases, 17 is an NA. Does the alien have the experience as required for the requested job opportunity indicated in H6? What that usually means is, let's say I'm hiring someone as an accountant, and I say, well, they have to have experience as an accountant, right? Well, do I put yes, no, or NA? But remember, if I go down to number 20, there's the alternative, right? Because I could say, oh, they have to have experience in the job offered, or maybe, I don't know, as a bookkeeper, right? So maybe when I hired them, they didn't have any experience yet as an accountant. They had their degree, but they didn't have any experience as an accountant. So I checked no to number 18, but I can check yes to number 20 because they do have the experience in the alternative, right? So there's that interplay between 18 and 20 in terms of, what is my primary experience requirement? What is my alternative experience requirement? And then again, which is the one that the employee meets, right? Maybe both, maybe the alternative. And again, if it doesn't apply, you just check NA. If it wasn't actually in the perm, you just do NA. Does the alien possess the alternative combination of education experience as indicated in H8? Again, if we said it was a bachelor's in 5 is the primary and a master's in 3 is the secondary, maybe this person has a master's in 3. So there to number 19, we would check yes, because they meet the alternative requirements, not the primary requirements. 21 is another, just a mess. Andrew, talk to me about number 21.
All right. So, did the alien gain any of the qualifying experience with the employer in a position substantially comparable to the job opportunity requested? So, here the real big thing is it substantially comparable? So, if you are, like we were talking about before, going for a position at a higher level than what they are currently working at with the same company, so say they're currently, let's just go with a junior software developer, but the perm is for a senior software developer. As long as you can show that that senior software developer, or better, a manager, is 50% different, then you can use the qualifying experience. If it's not, then you can't be using qualifying experience from the same employer.
Yeah, I mean, the main question here is am I or can I use my experience with this current employer towards the experience requirements of the perm? We try to avoid that where possible. So if we say this person needs a degree in accounting and 2 years of experience as an accountant, then we're hoping that when he was hired, if he's already working for the company, when he was hired, he already had those 2 years of experience. But if they're saying they require 2 years of experience and they hired him straight out of college, then this isn't going to work, right? Then the requirements were too high, right? We should have put essentially just a bachelor's and no experience because that was how you hired this guy, right? The way to kind of get around that problem is to do the perm for a higher position that's at least 50% different. Then we're saying, okay, we're going to hire you as a financial analyst, and then, but then we're going to do the perm for like an auditor, right? And then we're going to argue that the auditor requires a degree in accounting and 2 years of experience in the job offered or something related, financial, saying financial, not just related, and then we're able to use your experience with the employer because we're going to argue that the position of financial analyst and auditor are at least 50% different. Again, this is one of those things where we do it, we try to avoid it. We do it when we have to. And if you do it, be prepared for an audit. And also be prepared not only to be audited by the Department of Labor, but you're also going to get challenged by USCIS when you file your I-140. So usually we prepare a letter from the employer where we kind of line up the jobs, and it's this whole explanation as to why they are 50% different. This whole letter we prepare and sign and we submit when we submit the I-140. So 21 is another one of these questions that can get you tripped up. And it's one of these questions that you had to have had worked out back when you filed the prevailing wage determination. Because if you're just realizing this now at this stage, you may be toast. If for some reason the employee is now saying, "Oh no," or you're looking at their resume and you're like, "Wait a second, you didn't have any experience before they hired you." Because again, you can't require anything more than what they had at the time they hired them if you're doing it for the same position. Number 22, did the employer pay for any of the education or training necessary? I mean, yes or no. For us, that's no 100% of the time. And I love number 23. Number 23 is one of these really stupid questions that, like, I'm not sure why it's like so important that they actually ask it, but if you screw it up and answer it wrong, you can get denied. Is the alien currently employed by the petitioning employer? Again, this is for a future position, so like, why is that a relevant question? Who cares? But hey, if you screw it up, you can get in trouble. Now we get into funneled section K. So section K is where we list out the employee's experience, right? And we list them out one by one, starting with if they're currently working for the employer, then we're putting their current position, right? So under job one, it's very often sometimes that job one matches. If we go all the way back to the first, like the second page where we were putting in the job requirements and the job title and requirements, a lot of times that section and job one here are identical. They're a one-to-one match, right? Because the perm is for the position they're in. But hey, we do have those rare cases in which they're actually not currently working for the employer that's sponsoring the perm. Whatever. You put in the job. Again, since we have to prove specific periods of time, let's say 2 years, it is very important to be precise on dates. You're not going to be like, well, no, I started in October, right? But then I ended in July. And it's like, no, you have to be extremely precise on your dates because the Department of Labor is going to add it up. And if it requires 2 years of experience and the dates on the 9089 add up to 1 year and 364 days, denied, right? Just denied because you screwed up. And again, also, if you're saying that I have, the required experience in a certain job, you want to make sure, you're looking at your job title, the type of business, making sure everything lines up, number of hours worked, right? Obviously, because they're looking there to see, is it full-time? Is it part-time? Here, it says the past 3 years, but obviously if your experience is more than that, like if it requires 5 years of experience, then obviously we list everything out. We need to. So we skip down to the next page here. You see that there is a big box for all of our jobs to add in the job details. And this is another one of those areas where it's, hey, that big box, use it, man. Put what you need to put in there. Andrew, how do people get tripped up by not necessarily using box 9 correctly?
I mean, putting in not enough detail, not matching it up to the employer verification letter that they really should have gotten by this stage. Those are kind of the big ones, but the main thing is it needs to have all the detail from the previous job, and you need to make sure that that information matches across the board, meaning that if you're saying that you met the requirements for experience for the current position by working this job, then you need to list out enough detail to show that your experience with the previous job matches the perm job. And then also your employment verification letters for when we get to the I-140 stage have to include all of that same information.
Let's say back in your requirements, right? It included, let's say, experience, and the experience included cloud platforms such as Azure or AWS, right? The words Azure and AWS better freaking appear in job 9. Period. If they don't see, like you have to spoon feed them. Like it has to be clear and convincing. You cannot just assume they will understand. So if you're saying they have to, I don't know, understand, C++, right? Well, the words C++ better appear in one of these section 9, right? And again, and if it's 2 years and the first one's only 1 year, then it better be appearing in 2, right? Because it needs to add up to 2 years. So it's absolutely critical that anything that is required in the earlier section shows up in box 9. And when I say shows up, it shows up literally. Like those words show up. This is also the place where you can put in different like certifications. Because remember, if I'm saying this position is for an accountant and it not only requires a degree, but we want them to have their CPA, right? Well, that means they had to have had their CPA at the time of hire. Well, where do I enter their CPA? There's no field for me to enter their certifications. It doesn't exist, right? Well, let's say they got their CPA between 2012 and 2014, right? And job 2 was from 2012 to 2015, meaning they got their CPA during job 2. Then down at the very bottom of number 9 in job 2, put CPA license received from the state of Texas on this date. It needs to appear in the perm, right? You cannot let them don't leave it up to them to try to put 2 and 2 together. It needs to be explicit. I can't emphasize enough. Use box 9 to your full advantage. So put in languages, put in certifications, put in everything that you can reasonably fit into there so that they see it. Another one is sometimes, it's industry related. Oh, this guy needs to have experience in the oil and gas industry. Well, under you put the employer name. A lot of times the employer name doesn't help because this is some random name. There is type of business, so you can put there, right? But sometimes under the job details, we just put like a little 2-sentence employer description. This employer is a service provider to the oil and gas industry, focusing on, I don't know, pipeline maintenance. Like we add that little sentence and then we put the job duties, right? So it's clear as day that if one of the experience requirements was related specifically to, like, I don't know, the oil and gas services industry, there's no doubt whatsoever that job 2 involved, services in the oil and gas industry. Use box 9 to your full advantage and put languages, certifications, and then make sure this is why up front we we craft the job requirements when we're doing the prevailing wage. We then help draft an employment verification letters that incorporates that language. And then we then send it to the employee. And we say, employee, go back to your old employers and get this letter signed. There's some parts here up the top that the old employer can obviously fill in and add, but there's some stuff down here at the bottom that needs to be in there. It needs to stay there. Because again, at the end of the day, you have to be able to back up every one of these with an employment verification letter. Then as you scroll down to the next pages, you can add in more job opportunities. And then there is a section where everybody ends up signing, but you actually don't usually end up signing all of that until it's certified, it's approved, right? So when it's certified and approved, they'll send it to you and it will be signed by the Department of Labor. And then when you go to file your I-140, right, you take this certified one and then you get, the attorney signs it, the HR signs it, and then the employee signs it, and then you submit it with your I-140. Whew, okay, so the 9089, but how long do these take in terms of we go online, fill it all out, click submit? How long does it usually take to get an answer?
Around 160 days, assuming there's no audit.
When we submit the perm online, are we usually submitting any documentation alongside?
No, so generally when we're submitting the perm, it is just the perm all submitted online.
That's why it's, again, so important to use those fields to add in, like those section 9, to add in all that little detail, right? Because again, you're sitting here thinking, I got this great audit file and I got all this info, I got his transcripts and I got his employment verification. They're not seeing any of that, right? So that's why you have to get as much of that into the perm as you can. Use those fields that allow you to kind of put in additional information. Um, but and Once it's submitted electronically, is there anything the employer needs to do?
So the employer will actually receive a short questionnaire immediately after it's been submitted, and that's going to go to the contact information. So again, all that has to be perfect, especially the email address. And then they will have 30 days after they receive that questionnaire to fill it out and submit it.
And if they don't get the email, they don't fill it out, what happens?
Then everything's for naught and it's rejected.
So, Andrew, you mentioned audits. The DOL conducts audits. So what triggers an audit?
So the DOL, some of them are random. They just pick a certain number to run the audit on, but there's also certain that are triggered by a list that the DOL has of certain things that require an audit.
And we also mentioned some of the boxes on the 9089 itself, right? That if you check yes to, we're almost automatically going to trigger an audit, right? So when the DOL audits a perm, what are they looking for?
So, in 100% of the audits, whether they're random or targeted, the DOL requests all the information related to the recruitment, including a detailed recruitment report.
So remember, no matter what the reason is, they're even if the reason is they really want to audit you about a language requirement, they're still going to audit about recruitment. They always audit about recruitment. If it's just recruitment, then that usually means it was a random audit. Um, but again, that's now where you have to send them copies of the Sunday ads, copies of your SWA ad, copies of your notice of filing. That's why you need to have this all on hand, all saved. You have to have that recruitment report. And again, it's very important that you go look up what goes into a recruitment report, because uh, they're very demanding in terms of, hey, the rules say it has to have A through F, and it better have A through F, right? Because if you're missing like one little detail in the recruitment report, they'll just deny the whole thing. Even though you did your recruitment 100% correctly and you gave them all the ads, just because this one piece of paper was missing like one little piece of information that was otherwise covered, they'll deny it, right? So it's really important. Um, so what are like just some of the audit triggers?
We kind of went over some of the boxes, close family ties with the owners of the business, direct ownership of the business, recent layoffs within that company, training or experience from the petitioner, the employer received payment from the beneficiary, any of these things.
Yeah, so again,
Yes.
a lot of them just come back to boxes that you check on the form, right? And those can trigger an audit. Um, has the DOL released any just information about some of their audit triggers, or what they want to audit?
Yes. So back in 2013, they released information related to audit tiers.
So this is an interesting document. If you look it up, you can find it online. But this is about some of the things that they look at, right? So like the primary requirements are less than a bachelor's degree. Um, I guess they conduct. I think I saw some numbers around 50. Like they try to audit about 50% of those. The random audits where they're really looking at the recruitment. There's certain trade related occupations, and you can actually look up a document where they designate the SOC codes. Public schools, but it's actually specific public schools based on the EIN, and they will not say which ones. But just as an example, if you're in the DFW area and you work for Garland ISD in particular, and you can just Google this and figure out why. But there was quite the scandal. And so, I mean, I don't know this for sure, but I wouldn't be surprised if Garland ISD is one of the ones on their list where they're just like, yeah, we're going to audit all these, because there was some issues there. Um, Obviously, no experience is another one. Um, where they've had employers indicated they've had layoffs is another one. They go down this list in terms of um, their audit cases, audit priorities. I mean, I think there's a whole second page to this thing. But this kind of gives you an idea of some of the, oh, there we go, some of the different things they're going to audit for. Another one is supervised recruitment. We didn't even go through that, but that's basically like if your perm was denied and then you refiled a new perm within the same calendar year, you may get put into supervised recruitment. That's where the DOL actually like tells you how you have to do your recruitment. It's a pain in the ass. It takes a long time and ends up being way more expensive. You want to avoid supervised recruitment. So again, this is just kind of a flavor of the different stuff that they're auditing. So what are the most common audits that we tend to deal with within our firm?
These involve questions like business necessity, where the DOL questions the job requirements, usually is either excessive, including education, experience, language certifications, that sort of thing.
Yeah, so this is things like the DOL considers normal to have like a bachelor's degree and the employer is requiring a master's, right? That could potentially trigger an audit where they come back and they say, "We'll show the business necessity." That seems kind of unlikely because this is a bachelor's to a master's. That would more just like bump you up wage levels. It's a little bit more where it's like the DOL considers this to not require a degree at all and you're requiring a master's. Or another one we've seen actually not that long ago was um, an employer wanted to require 8 years of experience. And we're like, just so you know, the Department of Labor norm is 2 for this position. And if you go up to like 5, you're just going to get wage level bumps, but they're not going to audit you. You go above 5 and now you're risking an audit. Well, employer's like, no, 8 has to be 8. I can't lower that. That's the minimum requirement. And lo and behold, we got audited, right? And the Department of Labor basically comes back and says, this isn't normal. So prove you have a business necessity for this. And probably the most common one is language, right? So ideally, if you're like doing a perm for a Spanish teacher and you require Spanish, they're not going to audit that because they're gonna be like, duh, like it's inherent to the position, right? But if you're like, hey, I have a plant manager, the plant's based in the US and Spanish is required, they're gonna be like, well, show us that the business necessity. And that at that point, you'd have to prove a plant manager, they're not client facing, right? They're just dealing with employees. Well, you have to prove that a majority of your employees communicate in Spanish. So language is probably the most common one we've seen. It's usually fairly easy to deal with if you go into it prepared, meaning from the beginning you knew this was going to be there, you knew it was probably going to be audited, and you knew you were going to have to document it, right? That's why up front, we challenge the employer at the prevailing wage stage, like, oh yeah, Spanish is needed. Is it really needed? Can you show that a majority of your customers or employees speak this language? If they say no, then we're like, well, we can't include it. So you just get rid of it up front. But if they insist yes, then okay, then you include it. So the most common audits, that are not random in recruitment are something related to business necessity, to something that was within the requirements of the perm itself. How do we receive the audit?
So it's actually sent in an email and looks similar to RFEs that we'll deal with, where it lists out all the different things that they're auditing based on.
How long do we usually have to respond to an audit?
Generally 30 days, so 1 month to send out the audit packet, which, if you've been preparing from the start, should be pretty straightforward.
And then how do we respond to the audit?
So we actually upload the documents through the same website that the perm is submitted through.
That is the one nice thing about the Department of Labor. Like I said, hey, their website's not perfect, but at least they're uh, light years ahead of USCIS, who just started doing online stuff. There's only a few forms we can do. When they first started, you couldn't upload anything. They have added uploadability, but it's like USCIS is kind of behind the curve on the Department of Labor. So once the perm is approved, how long is it good for?
So it's valid for 180 days, which ultimately means that within that 180 days, you need to put together the I-140 and submit that to USCIS.
And that is going to be our next video, which is all about the I-140 ability to pay, the next step in this perm labor certification process. So We've done a video on prevailing wage, we've done a video on recruitment, and this video was on the filing the actual perm. So one more to sort of wrap up and conclude our perm labor certification series. If you're interested in some of the other employment-based categories, we've already done videos on EB-1A extraordinary ability, EB-2 national interest waiver, EB-1C multinational managers, EB-4 religious, and we have an upcoming series on the EB-5. If you're interested in any of the non-immigrant visa categories, we've pretty much covered them all in separate videos, E's, TNs, L's, H's. Go back and look. Otherwise, if you have any questions, right, you can go to our website, schedule a consultation, call, email us, look us up on socials. We are here to answer your questions. That is what we do. That is, what we live for, is to give people the right advice and then help them with their cases. As always, download our app, Law Pilot Guardian, Android or iOS. A lot of great information there and useful tools. Andrew, thank you as always, and we will see you in our next video.